You're listening to a special edition of We Get Work, recorded live from Workplace Horizons 2025 in New York City, Jackson Lewis's annual labor and employment law conference. Over 500 representatives from 260 companies gathered together to share valuable insights and best practices on workplace law issues impacting their business today. Here's your personal invitation to get the insights from the conference delivered directly to you. We'll see you in 2026. Adrian and Adriana, welcome to Live from Workplace Horizons 2025 and our We Get Work podcast series. Thank you for joining us today and taking time out of your busy conference schedule to come and talk to us this afternoon. So I'd like to introduce Adrian Conrad and welcome you to the podcast mic, a principal in our San Diego office, and Adriana Medensi, a principal in the Atlanta office of Jackson Lewis. Adriana, why don't you start by telling us a little bit about yourself, what your practice is all about, and what really employers are focused on these days?
Sure. Thanks for having us. As you mentioned, I am a principal in the Atlanta office, and I have been practicing law in Georgia for about 20 years. My practice is primarily in the restrictive covenant and trade secret space. So a combination of advising clients on those types of agreements and things they can be doing proactively to protect their information, and then as well as handling the litigation when things go awry, both on the plaintiff side and on the defense side. And what is driving the practice right now, and what we're going to talk a little bit about today, is what employers can and should be doing in light of all of the activity at the federal and state level on restrictive covenants that's hostile to restrictive covenants. So ways around that.
All right, great. And Adrian, tell us a little bit about yourself.
As you mentioned, I'm a principal in the San Diego office for the last almost 8 years. Before that, I was in our Jacksonville, Florida office for 7 years. And like Adriana, I am in the practice group around restrictive covenant litigation, but I'm also part of the arbitration practice group and the trial practice group. And right now, in the restrictive covenant space, the majority of what I've been doing, particularly in California, because we often don't get to the litigation part of it because you can't have your traditional non-competes or traditional non-solicitations. I've been doing a lot of cease and desist letters around what you can have, which are the confidentiality provisions, responding to cease and desist letters or sending them out on behalf of our clients.
Terrific. Thank you. So Adriana, you hinted at this. The title of your presentation is Open Season on Restrictive Covenants and really protecting your client's confidential information. So can you share a little bit about what your presentation was about and, what you shared with your audience here at Workplace Horizons?
Sure. Absolutely. So part of the presentation was focused on just sort of a check-in. What is the state of the law, both at the federal level, but we're also seeing a lot of activity at the state level. Every state has a different approach to restrictive covenants and is doing different things. So we talked a little bit about that. But the main focus was, well, what can employers be doing separate from restrictive covenants? If it's hard to keep up with changes in the law, or we think that we're in a jurisdiction that's hostile, what other things can we be doing to protect our trade secret and our confidential information that's totally independent from that? So talking through those strategies and really lessons learned that Adrian and I have from our experience in litigating these cases and taking them to trial. What are mistakes that we see clients make or missed opportunities? So hopefully giving our attendees those lessons learned and things they can take back and implement today.
And Adrian, from a legal perspective, what were some of the issues that were really important to cover today?
The missed opportunities and mistakes that Adriana mentioned. Key one being, what are your trade secrets? What are your confidential information that you should be keeping protected and that you should go after employees for if they're leaving the company and taking that information? And what we find is that many times employers are completely confused about what it is that they should be protecting. And I always tell this story because I feel like it's a really good explanation of it. which is in Florida, where you could have non-competes, non-solicitations, and of course, confidentiality provisions. Because you have the non-competes, that's all the employers were focused on. It was easy. It could be, if the employee left and they went one block down the street and opened up shop and was competing, that was what we focused on. There's a non-compete, we can shut them down. And then when I would say, hey, we can also add in there, that they're violating, the trade secret laws. What are your trade secrets? Oh, we don't know. Just go after the non-compete. So when I moved to California, I thought, okay, California, what you can protect is the trade secrets. So California employers should know what their trade secrets are, and they don't. So that's one of the things that we've talked about in our presentation was how important it is to identify what your trade secrets are, because as Adriana mentioned, with all of the changes at the federal level and the state level, they're all kind of moving in the way of California. And so eventually employers are really going to have to focus on those confidential trade secret information and how you protect it.
One of the reasons we have this conference is because there's an awful lot of law for employers to keep track of every single day. And I know there's a tremendous amount of activity in the restrictive covenant space over the past year. So between Workplace Horizons 2025 and Workplace Horizons 2026, Adriana, can you tell us a little bit about some of those significant changes and where the focus really is right now?
Sure. Well, we saw a lot of activity at the federal level that last year, and that appears for now to be somewhat stalled out. Where we are now seeing more aggressive behavior is at the state level. And I think where the focus tends to be, just at a 50,000-foot view, states are really focused on sort of the threshold issues when requiring employees to execute restrictive covenants. So are we talking about employees that make above a certain threshold? Are we talking about employees that perform certain particular duties as opposed to, somebody who is being paid by the hour and doesn't perform a job with a specialized skill? Really, states tend to be focusing on those bigger threshold issues. What are we giving employees in exchange for these agreements? And are we making sure that we are limiting the enforceability of these agreements to employees who can truly hurt the employer when they leave? I think that's what, would you agree, is sort of the consistent trend at the state level. It looks different in every state, which is part of the headache for employers, but I think generally that's how we would describe it.
So Adrian, you talked about knowing what your confidential information is in the first place. I'm assuming that's one of the ways that the Jackson Lewis team can really help employers get a handle on what they have to grapple with. What would you say are some of the others or some key takeaways that you would give to our listening audience today?
Key takeaways would be, because of all of the different changes at the state level, and even though the FTC rule, which would be effectively banning all non-competes and anything that acts like a non-compete, is currently, set aside, what employers are kind of grappling with is, okay, well, what do we do now? If it goes into effect, or if all these states now start banning non-competes, what else do we have to protect our information? And so one of the things that we're always talking through with California employers is, because they think we can't have anything to protect ourselves. And that really isn't true. You can still have a non-disclosure or confidentiality provision. You can't be overbroad, you can't overreach, where it's going to be treated as effectively a non-compete. But you can have those provisions, and you also have things like the state laws and federal laws that protect trade secret information. And you have tort actions as well that can help protect the employer. So the key takeaways are that there are still protections, and that you have to be careful about how you implement them, get an attorney involved to help you through that process, and to make sure that you're reviewing those agreements on a regular basis because of all of the changes in the law.
Thank you, Adrian. Adriana, what else might you add to that list of key takeaways if you had to share some insights with our audience here at the conference and on the other end of our microphones?
Sure. I think that was great advice. I think one of the big takeaways, hopefully, from our presentation was don't wait until you have a crisis. There is so much employers can do on the front end, identifying their trade secrets, working with IT to protect the trade secrets, having a plan in place when employees leave, so that you know what your action plan is. If you have a situation where an employee has left and taken your information and you call us, there is a lot we can do to help, but there's so much employers can be doing on the front end to prevent that scenario. And so don't wait until you have a crisis, implement measures now to get ahead of it.
And on top of that, even if there's some things they haven't done in the forefront of it to make sure that they get ahead of it, that when the employee does walk out the door, to please get involved with outside counsel as soon as possible to grab those laptops. Don't issue them to another employee and have them start. Now you're losing valuable information. Checking their history on how they were using their emails and whether or not they were emailing information to themselves. There's valuable information that can help us be able to help the employer when it goes to litigation, because even if you don't have an inkling at the beginning what the employee was doing, if you grab that information, sometimes you find out that they were setting up for it before they even left. And then you have a breach of fiduciary duty or a breach of loyalty that you can add on to the cause of action as well.
Things you definitely want to avoid. So we're hearing a lot about proactivity and process, and it sounds like you both are in agreement that in this particular area of the law, it's something else to consider as well. Adriana, thank you so much for being with us today at We Get Work, live from Workplace Horizons, and enjoy the rest of the conference.
Thank you.
Thank you for listening to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate a workforce that is engaged and stable. Please tune into our next program, where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on your streaming platform of choice, including Apple Podcasts, Spotify, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.